The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The Clerk of the Supreme Court receives documents for the Supreme Court. The Clerk supervises the Court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The Clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the Court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the Court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The Court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The Clerk of the Supreme Court receives documents for the Supreme Court. The Clerk supervises the Court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The Clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the Court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the Court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota.
Honorable Chief Justice and Justices of the Supreme Court. The Honorable Supreme Court of the State of North Dakota is now in session.
Good morning. Please be seated. We are here on file number 2025-0335, Matthew Ferderer versus North Dakota Department of Health and Human Services. Sitting today are Justices Dan Crothers, Justice John Jensen, Justice Douglas Farr. I am Lisa Fair McEvers, and Justice Jared Tufte is unavoidably absent, but he will be participating in this decision through participation of the briefs, the record, and review of the oral argument at a later time. Arguing today is Bradley Peterson for the appellant, and appearing is Micah Olson, and counsel for the appellee is Sarah Green. So, Mr. Peterson, you may proceed. And it's my understanding you have 5 minutes reserved for rebuttal.
Correct.
Thank you.
Madam Chief Justice, members of the court, my name is Brad Peterson. I'm along with Michael Olson. We're with the North Dakota Protection Advocacy Project. We represent the interest of appellant Matthew Ferderer. Mr. Ferderer is appealing a 2024 denial of a family paid caregiver application. I'll keep it simple, Your Honors. This case turns on how this court interprets the function of an assessment tool used by the department to deny the Ferderer's application. The department wants you to believe the assessment tool is an internal device. I believe on page 25 of their brief, they reference it as an investigatorial tool. It's insignificant. The department wants you to believe that Chapter 2832 and the provisions of it, the rulemaking provisions of it, do not apply. The certified record, transcript, prior decisions from this court, the legislative history tell a different story. So let's begin. Let's start with the certified record. What I'm referencing here is, and specifically it's located at index 34, page 263 of the record, specifically paragraph 17. This is the decision of the Administrative Law Judge, Jessica Binder. Administrative Law Judge Jessica Binder, at paragraph 17 of her recommended order, emphasizes the department's determination is based solely on a score derived from the assessment tool. There was nothing the ALJ considered with respect to the minor child's medical history, current needs, current educational records. None of that was considered. It was all or nothing. It was the assessment tool. And the score the Ferderers achieved on that assessment was too low. She was denied. The function of that assessment tool was the gatekeeper of her eligibility, nothing else. So let's move on to the transcript. Again, page 28, paragraph 38 of our brief, we have this court, or we explain to this court, specific statements of Kayla Fender. Ms. Fender is the program administrator for the Family Paid Caregiver Program. Her testimony is very insightful, very insightful. She tells us that this program is solely a state program. There is no federal overlay, there is no federal funds, there is no federal guidelines. This is important when we start discussing a trilogy of cases that this court has decided and act upon on issues similar to this. Also, we learned from Ms. Fender at page 171 of the record, line 16 through 25, no federal laws involved. And we also learned from Ms. Fender, this was not made public. There was no public input when this thing was created. The assessment tool was created. There was no public input. This was done by an internal committee. at the department. We also learned from Ms. Fender at the record at page 161, line 19 through 24, this is strictly a numerical scoring issue. Nothing else decided or denied the Ferderer application. She acknowledges in her testimony it's a rubric. She acknowledges it's a rubric, this assessment tool. That's not something that's set on a shelf. A rubric is used, as this court's well aware, to determine eligibility or to determine factors. That's a very key point. If you add the certified record with the transcript, we're looking at a gatekeeper function. We are not looking at some aid that's tucked away in a corner that the department may or may not want to use. This is a key. It's a gatekeeping function. Because it's a gatekeeping function, the provisions of Chapter 2832 apply. 2832 apply, and as the court's aware, that's the Administrative Agency Practices Act. In that act, or in Chapter 2832, there's special provisions that tell us how a rule is to be made or to be used. The department's assessment tool doesn't follow that. It didn't follow the rulemaking process. So let's move on to the third issue, or the third event, the trilogy of cases from this court. Okay, again, remember right now, we have the certified record, we have the transcript that look like a gatekeeper function. Meaning, to be eligible for this program, and I believe only 150 individuals were allowed to be found eligible, they had to go through this assessment. So now the trilogy of cases, we're looking at Bruner versus Ward County Social Services, Mullins versus the Department of Human Services, and finally Rennick versus the Department of Human Services. And I know I want this court to read these cases together. It's easy to read them separate, but if we read them together collectively, it stands for the premise when the department plays by the rules of Chapter 2832, this court defers, and it should. But when the department tries to turn internal policy into law, that deference ends, and the rule of law begins. We know that. Bruner tells us that when the department wanted to use something, that an internal policy or an internal device, they were okay with it. This court was okay with it because there was a federal legal framework that overlaid it. And the reality is the department was just basically a mouthpiece for the federal law. And that's typical for the departments. Department of Human Services, let's be real, the federal government dictates for the most part how the Department of Human Services carries out its functions. We know that, and they do that through the purse strings. We know that. But what's unique about this program is there is no federal overlay. There is no federal rulemaking. There is no federal instructions. There's no federal policy. No federal funds are involved. None. This is strictly a creature of the state of North Dakota trying to help families keep family members at home instead of having them institutionalized. That's the whole purpose of this law.
Mr. Peterson, does the fact that this is a pilot project play in anywhere?
That's an interesting question, and my initial thought was, my knee-jerk reaction is to say no, but the reality is a pilot program means it's testing the waters. So why would we want exclusion when we should be looking for inclusion? The department created a framework that doesn't benefit our state. And we know that because in the following legislative session, this past one in 2025, this law was changed. In it, the legislature says, oh, we gave too much authority to your department with this internal tool. We are now going to tell you in 2025 what we want in the assessment tool. But in 2023, they didn't. They gave the department the authority to create whatever they wanted.
And that's really my question. If it's a true pilot, it's pioneering. There's nothing, no federal rules or federal guidance. So they're trying to figure it out. Does that get baked into the legal analysis, or do we look at it through the same lens?
It doesn't, from my vantage point, Justice Crothers, it doesn't matter because the department never made this available, this assessment tool, for the public to engage in the rulemaking process.
The statute itself authorizes the department to adopt rules and expressly directs them to utilize an assessment. So doesn't the statute give them the authority to create the assessment tool?
Absolutely. The problem is when they created the assessment tool, they didn't follow 2832 and make it available to the public.
And why do they have to?
Because of the function of the assessment tool. The function of this assessment tool is a gatekeeper. It's not sitting on a shelf that the department can pull off and dust off and say, hey, we're going to use this. Any person who sought this program, any person, had to use that assessment tool. That's a function. That's a rule of law that should have been reduced to a policy analysis under 2832 and the rulemaking authority. The department skipped that. They felt that they could just use a computer program to sift through the program and call it good. We can't allow that.
I'm trying to relate this to other areas that I'm aware that use assessment tools for various things, and sometimes they are used in juvenile court to assess whether a child should be kept detained or not, or released. And in other instances, they are used for juveniles in the Department of Corrections to determine whether or not they are of a level that they need treatment. And so are you saying all of these tools that are used by the courts and by state agencies for those type of assessments also have to go through the rulemaking process?
Just the opposite, Justice McKeppers. What you're talking about is the YASI, the Youth Assessment Screening Instrument. That's what we use to determine placement of children. I've dealt with YASI up one side and down the other. It's well established. We know that every state, or majority of the states, use YASI. This thing was created in a back room, back door that nobody knows how it was created. Look at the transcript. Ms. Fender acknowledges she doesn't know where it came. We know, or it was derived from an internal meeting. There is nothing showing that's statistically reliable that it meets the requirements of an assessment.
Could they, when it's the first time, as Justice Crothers pointed out, on a pilot project, how can there be any other tool, since this is a unique state situation? This is not something that could be validated until they have one to start with in the first. There's no way to validate something that never existed before.
Thank you, and I agree with you. That's why it should have been made available to the public to discuss this, to ensure that this assessment tool would benefit the citizens of North Dakota instead of being used as an exclusion. It should have been used as an inclusion. The 44 questions of this assessment, there's no rhyme or reason to it. Some are based on age, some are not based on age. Some are based upon factor that don't include other factors. The problem with this whole thing is there's no individual review at any point. We can use the assessment tool, I don't care. But if a person is denied only using that assessment tool, there needs to be some kind of individual review or judgment used by the department. That's what this court told us in Rennick. Rennick told us that a computer tool, yeah, okay, we're okay with it as long as there wasn't an individual needs or an individual assessment available. Rennick also told us the department's use of a personal judgment is enough to offset that computer tool. We don't have this here. The computer tool is the be-all, end-all. That cannot happen. It doesn't benefit the people of North Dakota. If we could...
How do we square that with the language in the statute that the Chief Justice was referring to? I'm talking about 5024.147 sub 3, where it gives the department authority to, it said, may adopt rules and establish eligibility requirements and exclusions. It seems that that's exactly what the statute said the department should be doing at this time.
Again, my concern, Justice Carruthers, and to this whole court is the method. The assessment is the only determining factor. There is no individual review. Rennick told us there needs to be some type of an individual review built in. Without that individual review, and I guess going back to Madam Chief Justice's question about the Yazzie, I had the opportunity to challenge that when a score was derived on a child, and that score said that child was going to ICC. I had a hearing to question how that score was derived. We would go down one by one. Oh, you missed that. Yeah, I did. Did you miss that? Yeah. There is no opportunity here. As Justice Binder told us, or Administrative Law Judge Binder told us, the number is it. Nothing else goes beyond that. That should scare this court. It shouldn't be saying, hey, that's a great idea. How about we do the assessment tool, but also build in an individual needs, also build in personal judgment, like Rennick told us. If we look at the legislative history, Director Tina Bay from the department, she told the committee that they were going to consider each individual's needs when authorizing services. Show me where that happened. It didn't. She was denied because of a score. Nothing else. Nothing else. Back to the trilogy of cases, the Bruner, Mullins, and Rennick case, Mullins tells us we're going to draw the line at deference to the department. When it follows the law, great. When it creates its own law, not so much. Mullins is very important here because it teaches us the department cannot use informal guidelines to restrict access to statutory benefits. That's what they did. They used an assessment tool that nobody knew about except for people in this room, or in the room up at the department. That's it. It was never made available. It's not like a driver's license test where I have a booklet I can study. If I go in and take the test, there's a right answer there. That's not what this assessment tool was. You would score it, yes or no, based on your categories, and then the department would assign or place weight on certain questions. Okay. For example, my client, the minor child who they care for, has very complex medical needs. She goes to therapy sessions multiple times, physical therapy, occupational therapy, speech therapy. On the assessment tool, she scored a score of 0. The reason why she scored a score of 0 is solely because of her age. She wasn't 11. So any child 10 or younger gets a 0 even though they go to multiple therapy sessions. How on earth does that make sense?
Well,
it doesn't.
Thinking about that, the types of things that this child is going to, and I'm not trying to be argumentative, but couldn't children who don't have as great a need as your client also have to go to those exact same kind of therapy sessions? Many children have to go to speech therapy and occupational therapy and all of these, many children. And so how do you show that your client is the extraordinary child?
With respect to the therapies, my client got a score of 0. She didn't get any score on the therapy question solely because of her age. But yet that assessment has nothing in there for transplants. She would have scored a 5 on that question. She got a 0 on therapy. She got a 0 on verbal aggression. Well, she only speaks 9 words. That's the problem. There's no individual need or individual review built in, even though Director Tina Bay promised the legislature there would be. There is no individual review. You can use the assessment, but if it's denied, there should be some kind of a mechanism where the family can tell the court or tell an administrative hearing officer or tell the department, individual needs matter, and here's why we want you to consider it based upon these voluminous medical records, these voluminous educational records, the daily needs and wants of this child. Those weren't factored in. It was the assessment, all or nothing, as ALJ Binder told us.
There were findings, though, on your client's medical history, were there not?
There were, and again, she commends the administrative law judge, the ability of these parents. They're incredible. I've got to know them very well. But if you read paragraph 17, it tells us all or nothing is the assessment score, and that's what decides this, nothing else. So basically, I argued for over 5 hours, or almost 5 hours in an administrative hearing, nothing. Because the only thing that mattered was the assessment score. And when we asked about the assessment score, we asked about the statistic reliability, we asked about how it was derived, the answers that we got from Ms. Ferderer, I don't know, I guess. We decided who, some people at the department, who, I'm not sure. Those were the answers we got. If you're going to use this assessment tool, you better have your ducks in a row. And the ducks are quacking, but they're not sitting in a row. That's the problem with this case. There is no individual review. Rennick told us that. Rennick told us, if you're going to use a computer program, we're okay with that, but it's not going to be the sole determining factor. We're going to have also the ability for individual review, and we're also going to allow the department to use its personal judgment, common sense. None of that was in play here. That's the problem with this case. And especially when the director, when Ms. Bay gets up and tells us, we're going to use individual needs or consider those, but yet they weren't. Why not? That's an ambiguity. If the department's making promises to the legislative branch of government and then not carrying them out, we have a disconnect there. And that disconnect came at the expense of my client. I just want them to have a fair shot, not the ability to do an online test and that be the be-all, end-all. It makes no sense. None. It's just like the Yazzie when we talked about it, Chief Justice. The Yazzie, when I go to court, I had the ability to argue that. I say I have some time issues here. So,
You have 4 minutes.
Okay. I wasn't sure how this worked. I just saw it went yellow on me.
And
So,
it goes
okay.
to yellow and it's 5 minutes left.
Gotcha.
So you have about 4 left.
All right,
Fine.
fair enough. I'll keep going then. That's the concern here is when we have Yazzie, we have the ability to challenge it. There is no ability to challenge this assessment, especially when the head of the program can't even tell me it's statistically reliable. It's never been held up to scrutiny. Yes, it's a brand new, but shouldn't we have something saying this is the reason why that particular question was included? There's a reason why we didn't include transplants in our assessment. That's the problem with this thing. It's good for 0 to 100. There's no special assessment device used for just for children. That should cause concerns right there. When we asked about how many children were found eligible, well, we think there were some. Couldn't give us a number. It's not, you have a mountain that cannot be climbed, basically, by a child when you're receiving 0 scores solely because of an age, even though they are receiving the benefit. She goes to therapy sessions a lot. She has an IEP. They're trying to integrate her into schools or into kindergarten or pre-K. They can't. She has to stay at home. They made a determination her health is too big of a risk if they put her in a school setting. None of that was factored. None of it. That's extraordinary. We also have the parents giving very compelling testimony both at the Legislative Assembly and at the hearing about trying to find anybody that can come in and provide care for their daughter. I believe in our reply brief we reference Matthew Ferderer's written testimony where he says, someone came drunk. Gee, that's who I want to see my kid. Watch my kid on a daily basis. Somebody that's intoxicated, doesn't show up, sits on their phone all day. Mom can provide these services. She quit her job to care for this child. She's simply asking the money's being used by a third party to provide the services. Why can't I get part of that at $77 a day? That's it. That's what we're talking about here. Again, there's a cap on this. It's only good for 6 months. Then it's subject to an ongoing or continuing review. The department can say after 6 months, you're done with this benefit. That's pretty significant. We do raise other arguments. The usurping argument basically is what we're trying to say is the department was given too much authority. As you guys, read back to me the law, the legislature did not contain the department in 2023. It did in 2025, but in 2023, it gave it unlimited authority over this program. That's not the function of the department. The department shouldn't have the ability to determine how much a person receives. That's a purse string function. The legislature should have authorized that or directed it. It shouldn't have said, you can create the standard without us reviewing it. You can create who's eligible and who's not eligible and for how long they're eligible or not eligible or the mechanism. There are too many what ifs. That's, I guess, the usurp argument in a nutshell. As far as Olmsted, that's always a concern when anytime we're dealing with a disability-related question. The good news is the department, in their brief, it looks like they finally backed off on their argument that Olmsted only applies when people are institutionalized. We believe that Olmsted applies prior or when a person is facing institutionalization. Olmsted should kick in. In this case, it was never even considered by the department in its determination of this program. Now I see I'm done. Thank you.
Thank you, Mr. Peterson. Ms. Green, you can proceed as soon as you're ready.
Thank you. May it please the court, Sarah Green representing the appellee North Dakota Department of Health and Human Services. This appeal is the result of an administrative hearing where the only issue noticed for determination was whether Ferderer's application to participate in the Family Paid Caregiver Pilot Program was properly denied by the department. The administrative law judge issued a recommendation order finding the department properly denied Ferderer's application, and the department adopted that order in total. Importantly, at the administrative hearing in this matter, the appellant did not offer any opening or closing statements, provide the ALJ with legal arguments by briefing or orally during the hearing. Therefore, the only argument that is properly before this court is whether Ferderer's application to participate in the Family Paid Caregiver Pilot Program was properly denied by the department. The department respectfully requests this court affirm the order and deny the request for attorney's fees, by holding the department properly denied Ferderer's application, and my argument today will focus on that issue. A decision of the administrative agency must be affirmed unless one of 8 factors identified in Section 2832-46 is demonstrated. The appellant does not contend that the department's finding of facts are not supported by the preponderance of the evidence, that they do not sufficiently address the evidence presented in the agency, or that the conclusion of law are unsupported by the finding of facts. Rather, the appellant's arguments raised for the first time on the appeal to district court and now to this court present question of law, but all of the arguments now raised have been waived as they were not presented during the administrative hearing on this matter. Again, the ALJ and thereby the department were not able to consider these arguments that are now being provided to this court. Because the findings of fact were not challenged on the appeal, the appellant waived the legal arguments now raised by not timely presenting them at the administrative hearing. The department's order must be affirmed by this court. And during the hearing, the Ferderer's counsel failed to preserve any grounds for appeal after waiving both the opening and closing arguments. I'm assuming you might have some questions for me at this time regarding this issue.
Yeah, let's start with the specificity. Assuming we are going to consider the legal issues on appeal, the charge from the legislature in Section 5024.147 to the department is pretty broad. It says, go develop rules if you want to. You may develop rules addressing management of the pilot project, and you may establish eligibility requirements and exclusions. How is that sufficient delegation of legislative authority to the department for us to say that there's sufficient guidance?
The department believes that there is sufficient guidance in the legislative authority that was provided due to the fact that it provides a definition, a two-part definition of what extraordinary care is meant to be. The assessment that is being utilized is just meant to determine whether or not applicants fall under that definition that was provided by the legislature to what means extraordinary care. In addition, the legislature also provided a maximum number of participants, which I believe was 120 participants, no more than that. Additionally, the maximum amount of funding, the legislature provided only a maximum amount of funds that was going to be provided to the pilot program. It also determined the number of employees that are meant to be used by the department to implement the pilot program.
So was the assessment tool designed to make sure that you didn't go over the limit of the 120? I mean, was it front-loaded to try to exclude people because they were concerned that there would be more applicants than they would have funding for?
The application was designed to determine whether or not an applicant's care that they were receiving was extraordinary care as the definition provided.
Go ahead.
How do we know that if there was no public hearing at all to address that eligibility requirement?
The assessment was actually created, and a sample assessment was provided to an advocacy group. The advocacy group then selected families, and a sample assessment was used. That's how it was created, and it's also
But
provided in the
this
testimony.
ultimately is a factor. I mean, it controls eligibility, correct?
It's not the only factor. There's several eligibility factors, but it is one of many.
They meet all the other ones. This excludes someone if they don't get a certain score.
If they're not extraordinary, that's what the basis of it is, whether or not the care is extraordinary.
But there was never a public hearing to determine what factors should be considered in determining whether someone is or is not, whether it's extraordinary care, correct? It's really simple. There was never a public hearing. You didn't go through the 2832 rulemaking process.
For the assessment itself, no, the assessment itself was not part of the rulemaking process. However, there were rulemaking process completed for this pilot program.
For other
The assessment
eligibility
itself.
requirements, but not this one.
I believe so, yes. It's my understanding that this assessment would actually not be considered a rule under the 2832. However, again, this was being brought for the first time. This was not brought at the administrative hearing level, just for clarification. That argument was not made at the administrative hearing. That decision could not have been made from the department at that level. Therefore, it should not be made at this, or it should not be considered properly in front of this court. Again, the pilot program was enacted by the Senate Bill 2276, which defines extraordinary care and authorizes the department to adopt rules establishing the eligibility requirements and to manage the
Could you go through the
program.
definition of extraordinary care for me?
Yes, Your Honor. Senate Bill 2276 defined extraordinary care as A, exceeding the range of activities a legally responsible individual would ordinarily perform in the household on behalf of an individual without extraordinary medical or behavioral needs, and B, is necessary to assure the health and welfare and avoid institutionalization of the individual in need of care. Again, it's not the complex history, medical history of the individual that is being determined as extraordinary. It's the care that is required. That care that is being required is dependent on the age of the individual, due to the fact that all 3-year-olds are going to need some type of monitoring. It's not uncommon for a 3-year-old to need additional supervision or help or assistance in using toiletry issues. It's not unusual that an
It's
individual...
unusual for children of any age to be having tubes, to be fed through tubes, to have to be kept out of school because they have a suppressed immune system. All of these things are not the usual.
The medical care, the medical is correct. That would be the unusual, that would be
I think
extraordinary.
it's unusual.
But the care,
If a child, and I guess I don't know all the facts of this child, but it's, by age 3, most children can use the toilet by themselves, and maybe the parent has to be there to supervise them, but it's not the same as having to fully take care of that by the parent, and it sounds like this child cannot use the bathroom.
it's my understanding that the information that was provided by the mother on the assessment is that she occasionally needs help. Not that she needs not that she's totally dependent, but that occasionally she needs help. And I believe that is what was listed on the assessment that was provided for toiletry. I believe that's on page 1 of the exhibit 2. That would be toiletry. It actually is something that I'm misinformed. I'm stand corrected. It actually is one of the questions that is not applicable to the age range. Not applicable to the age range of a child isn't that they don't receive any points, is that that question is not used. Although there's 44 questions on the assessment, that is one question that is not used either for or against the child.
Why does the age of the child matter? Or is that if a child was older, let's say this is a teenager and needed the same type of assistance in using the toilet that this child needed, would that be taken into consideration if they were 15?
Because of the fact that it would be above the age of 3, that question would be within the applicable range of a 15-year-old, but not for a 3-year-old.
Ms. Green, would you agree if the department said this funding, these services, no one caring for a child 3 or under will be eligible? Would you agree that would have to go through the administrative rule process?
I don't believe that's what was said here, though. Your Honor.
That wasn't my question. Do you agree that that kind of criteria would have to go through the administrative rule process? It's determining an absolute criteria. If your child's 3 or under, you're not eligible. Wouldn't that go through rulemaking?
Yes, if that was one of the eligibility factors, yes. However, this was eligible. This was through the 2832. This was properly promulgated under that. And again, this is being raised for the first time at this issue.
I understand that argument, but if a test or an assessment is done that basically accomplishes the same thing, we're not counting anything if you're under 3. Why shouldn't that go through the same process as a rule that says we don't consider you if you're 3 or under?
The reason why is because this assessment itself should not need to be promulgated due to the fact that it is a rule that could be abused. By placing it on as a rule, it could be abused as well as knowing. Because this assessment is not conducted by the department. This assessment is filled out and conducted by the applicant or the legally responsible.
By telling people the eligibility requirements, it could be abused because now you know the eligibility requirements?
No, the assessment itself, the questions themselves. Also because of the fact that this is a pilot program, the assessment, it just needs to be the way that it was promulgated is the assessment that's approved by the state, by the department.
I'm not sure why, if you're denying people certain benefits, why does it matter if it's a pilot program? You're still denying them now.
Again, the denial is due to the fact that the extraordinary care, the care that it was being required for the child was not considered extraordinary due to the level of care and the types of care that was being provided in comparison to any other 3-year-old. That's what ultimately why the child was denied, was for that reason.
Is it the department's position that all of the legal issues that are on appeal have been waived? They were not preserved?
Yes, Your Honor. Yes. All issues before the court right now were not reserved, or not preserved at the administrative hearing.
Does that conclude your argument?
Yes, Your Honor.
All right, thank you for your argument this morning. Mr. Peterson, you do have 5 minutes in rebuttal.
And Mr. Peterson, of course, a big question is, how did you preserve these issues?
May it please the court, Madam Chief Justice, Justices, the easy answer is turn to Index 36, Your Honors. Remember now, this is not a district court matter. This derives from an administrative appeals process. This court has routinely told us administrative appeals are different. We have the administrative, we have a 5-hour hearing. Now there's some questions about opening, closing statements. All 5 of you, I believe, minus Justice Crothers, have been district judges. Justice Crothers, you've tried a few cases. You know opening and closing statements are not evidence. Evidence is the 5 hours worth of hearing. Out of that hearing, Administrative Law Judge Jessica Binder issues her recommendations. The department adopts those all in a 3-sentence order. There's some things in there that don't make sense. So at Index 36, we file a request for reconsideration saying, hey, Justice or ALJ Binder jumped the shark. The department, again, in a very terse response, says, no, what you did was fine. Okay, we'll follow the appeals process. We'll raise it to the district court and say, hey, district court, the administrative law judge and the order she issued and was adopted by the department in full doesn't make sense. It's raised again. District Judge Reich said, Peterson, I got other things to do than waste my time on your appeal. He writes out an issue saying, you didn't get it right. Next step, I go before you. The method the department used to deny the Ferderer application was the assessment tool. It was the gatekeeper. The gatekeeper should have been reduced to writing through Chapter 2832 and the rulemaking process. I guess just to keep this simple, Your Honors, a computer program, no court has ever said a computer program pays the price for being wrong. Can't be held accountable. So what's the benefit of the taxpayers in North Dakota to allow state agencies to forgo human accountability and responsibility, instead replace it with a computer program? There isn't a benefit to that. We can't allow the department or any state agency to quietly replace statutes, the rulemaking, individual review or professional judgment with scoring assessments. We can't do that. We have to have a mechanism in place that once that score is derived, that can be questioned. And again, there were some questions about, the only issue before the administrative law judge was whether the application was denied. There was nothing in there saying it was going to be restricted to only looking at the scoring mechanism.
But one of my sticking points is we've got a program here, it's a pilot. The legislature specifies it's going to have 120 total participants. There's a certain amount of funds and a certain number of people. How do we factor that in to what your client's argument is? It seems that this was intended to be limiting, to exclude, by direction of the legislature.
On April 1st, 2024, there were a lot of parents or a lot of families online quickly answering 44 questions and hope they were one of the chosen. That's, to me, is anarchy. There's no individual review built into this. We're going to say, the first 120 that got the score we wanted, congratulations, you win the prize. We're not going to look at the disability that you actually have. We're not going to actually look at financial. I mean, Doug Burgum's family really didn't need this, but they scored right, so they're going to get it. While Ferderer family, boy, you really need it, but you know what? You suck at online test scoring, and because of that, we're not going to give it to you.
Mr. Peterson, your time is up.
Thank you.
Thank you for your argument, and Ms. Green, thank you for your argument as well. This case will be taken under advisement, as all cases are, and the court will stand adjourned until 10:45 a.m. Thank you.